Hello, everyone. Welcome to this AEI online discussion. My name is Marc. I'm a resident fellow at the American Enterprise Institute, and our topic today is the International Criminal Court and Global Criminal Justice, a conversation with Ambassador Morse H. If you have, we'll have a discussion first, and then we will go to questions. And if you'd like to submit a question, there are two ways to do it. You can send it to the following email address: Alexa, A-L-E-X-A, Santry, S-A-N-T-R-Y, @AEI.org, or you can tweet them with the hashtag AMBTAN, A-M-B-T-A-N, @AEI. So let me frame the discussion and then we'll go to Ambassador Tan. So the question before us is, should an unaccountable United Nations court created by a treaty which the United States is not a signatory to and which the United States Senate has not ratified be allowed to investigate, try, and even imprison United States citizens? Unfortunately, this is not a theoretical possibility. In November, of 2018, the chief prosecutor of the International Criminal Court announced she was seeking a formal investigation into alleged war crimes committed by US military forces and CIA officers in Afghanistan. And so this prosecutor, who is answerable to no government or institution, claims unbridled power to investigate, charge, and prosecute American citizens no matter what the US government says. The question is, who gave a foreign magistrate the power to try US citizens when our government hasn't assented to the treaty that through our own democratic institutions? The answer is no one, and yet they are preparing to do just that. The Trump administration has made pretty clear that they're not going to go along with that. And the man charged with making sure that doesn't happen is with us here today, Ambassador Tan. Ambassador Morse Tan was appointed by President Trump to serve as Ambassador-at-Large for Global Criminal Justice in December 2019, following his confirmation by the US Senate. He was before that serving as the youngest full professor of law at Northern Illinois University College of Law, where his areas of expertise included international criminal law, international human rights law, and constitutional law. He is a National Merit Scholar. He earned a BA and MA from Wheaton College and Northwestern University Pritzker School of Law. He's fluent in Korean and Spanish and plays the cello. So he's quite a Renaissance man. We are so pleased to have you here with us, Ambassador Tan, and set up the situation for us. What is going on with the International Criminal Court, and why is the Trump administration taking such decisive action to prevent them from investigating Americans?
Thank you, Marc. I appreciate that. And before I get into some of the legal aspects and what is going on along these lines, I wanted to start with an anecdote that I think will help to frame and introduce our topic of today. Those of us who witnessed the attacks on September 11th, 2001 will never forget the horror of the largest attack that happened on US soil. At that time, there was a 17-year-old named Thomas Patrick Payne, who, when he saw that attack, believed he found his calling to serve in the US military. He entered the US military, became an Army Ranger, and was deployed to various places in the Middle East, including Afghanistan. And there was a point when he was deployed in Iraq where there were mass graves being dug by ISIS because they were planning to execute some 75 hostages, Iraqi hostages that they had seized and imprisoned in 2 buildings in Iraq. A group of American soldiers was dispatched to rescue these hostages who were about to be executed by ISIS. And let me tell you, when one serves as I do in this area of global criminal justice and mass atrocity crimes, mass graves are far too familiar in terms of the mass atrocities that are there. They landed with their Chinook helicopter and were immediately subjected to strafing fire. And they stormed one of the buildings and in the midst of a hail of fire, freed some 38 hostages that were there. Then they were told that the second building was on fire and that there were additional 37 hostages who were there. They moved from that one building to the next building. They went to the roof and engaged the enemy who was holding these innocent hostages. And after that, they realized that they had to enter. So they came to the entrance and cut the locks and then stormed the place. It was on fire. The roof was in danger of collapsing, and yet they ran in and rescued these additional hostages. A total of some 75 hostages were rescued. He was the last man out, Major Sergeant Payne was, and was inhaling smoke. His superiors were in the midst of that, were urging him to depart because they feared for his life, but he risked his life and rescued these 75 hostages. Why do I share that? I share that because the United States of America, more than any other country in the world, engages in these sorts of interventions to try to prevent mass atrocities from happening and serving the cause of justice thereby. He risked his life for the sake of 75 people he had never met before. And the US needs room and space to be able to engage in things along these lines rather than having an international criminal court or any other body attempting to interfere or block or deter the US from being engaged in such activities. Another indication of the US commitment to justice is what happened just recently when there was an ISIS cell known as the Beatles because of their British citizenship at the time and the British accents that they had, who committed horrific torture, starvation, all sorts of inhumane acts, ultimately executing various Americans who they had captured. Just recently, the remaining Beatles, 2 of them that are left, were brought into US custody for prosecution in the most developed legal system on the planet, the American legal system. We have 5% of the world's population, but we have 70% of the world's attorneys, and we have a well-developed legal system that is considered a model for the world. And I will get back to this later in terms of a discussion of complementarity in terms of why this is significant. I want to share another sort of story as well that in terms of what transpired went horribly, horribly wrong. In Rwanda, when the genocide was unfolding there, the world was looking on in horror, but did not act decisively to stop or substantially mitigate this. There was all sorts of conversation that went on calling it genocide-like acts and dancing around the term genocide. And not only was there not sufficient intervention, there was the opposite. There was the withdrawal of troops who could have helped deter, mitigate, stop a lot of the massacre that was happening. In the Rwandan genocide, there were all sorts of crude weapons that were used, sharpened sticks, machetes, things that were very crude and simple and that a decisive intervention potentially could have stopped. However, to the shame of the world, that did not happen. And somewhere around 1 million Rwandans were slaughtered in the Rwandan genocide. The prevention and mitigation through some sort of intervention would have been best in that instance, but what the ICC has done with respect to opening up the investigation on potentially American personnel is that they have made it so that such interventions in the future would be deterred and would be discouraged and would be interfered with rather than happening. Thankfully, there was some accountability that occurred after the fact through the International Criminal Tribunal for Rwanda, which the first ambassador-at-large for then the War Crimes Office, later on in 2014, it was changed to Global Criminal Justice, set up this International Criminal Tribunal for Rwanda to try to provide a certain measure of accountability. My office has the War Crimes Rewards Program, where we are seeking accountability by providing incentives for the capture of those who were substantially involved and culpable for what happened in Rwanda. And I'm pleased to report that during my time in this office, Felicien Kabuga, who was one of the key instigators of the Rwandan genocide and also the chief financier of the Rwandan genocide after over 26 years of being at large, was captured outside in the suburbs of Paris. I mention this all because there is no country in the world that is in a better position to step in and provide a measure of justice, whether to prevent, whether to mitigate, or whether to provide accountability after the fact to these mass atrocity crimes that sadly have happened around the world. One of the aspects as to why it is illegitimate for the ICC to go after American personnel is, as Marc was mentioning earlier, we did not consent to the Rome Statute. And as a matter of fact, according to the Supremacy Clause of the US Constitution, it is our Constitution, the US Constitution, that is the highest, most supreme law of the land. And this is true above treaties, which we did not agree with in this case, or acts of Congress, which happened after the Rome Statute came into force. There was the American Servicemen Protection Act that sought to protect American servicemen from the reach of the court. But supreme over all of that is the US Constitution. And why does this matter? The International Criminal Court does not provide constitutional protections to the defendants who are brought before it. It is sub-constitutional in what it provides. For example, it does not provide a trial before a jury, which is guaranteed by the United States Constitution. And there are other due process concerns where the ICC operates at a sub-constitutional level. And so it behooves our country to not subject our own personnel and citizens to sub-constitutional prosecutions before a court that we did not agree to subject our citizens to. And let me mention a number of other legal problems that exist in regards to the ICC's attempts to assert jurisdiction potentially over our servicemen. There is a provision in the Rome Statute which needs amending that provides the prosecutor with the power to initiate prosecutions. It's called the Proprio Motu motion of the prosecutor. This is the motion that was employed in order to open up the Afghanistan investigation. This has become far more problematic because the ICC has abandoned its own internal checks in regards to Proprio Motu motions when the appeals chamber said that basically the judgment call in regards to that, based on the interests of justice, are entirely belongs to the prosecutor. The way it was supposed to work, the judges were supposed to provide a check, and yet that check has been abandoned. And now you have the possibility of a renegade prosecutor like this one, including US personnel, in prosecution. There's another problem, territorial jurisdiction. This provides that when there is an alleged atrocity that has taken place in a ICC member state, a non-member state citizen can be prosecuted when that occurred on the territory of a member state. We did not agree to this, and this also needs to be amended as well. In addition, the ICC was always styled as a court of last resort. This is enshrined in what is called complementarity. That means that if a national system is able and willing to engage in the prosecutions or investigations that are needed, that the ICC would not step in that instance. And what is problematic about the way the ICC has interpreted complementarity is that they are claiming that they can oversee each and every case. And if the case does not go to their liking, say a conviction, then they are able to step in. This differs from an understanding of complementarity that looks at the whole system and says, does this system have the capacity to be able to handle it, and are those in the system willing to do so? That was the understanding under which complementarity was agreed to by member states, and yet they have exceeded it. And not only have they exceeded it, they have flipped it on its head in certain instances. Even in a case not related to the United States, in the Central African Republic, the International Criminal Court has accorded to itself primacy jurisdiction, which means they are saying, we are first and we have jurisdiction first. We're not a court of last resort in this instance. We retain the right to have jurisdiction before any domestic court or even the hybrid court that has been set up in the Central African Republic. There's also the issue of gravity. When one looks at the situation in Afghanistan, anyone who knows even a cursory amount about what had transpired in Afghanistan knows that is the Taliban who has committed the bulk of the alleged atrocities that have been there. And when you're looking at the gravity requirement, you're supposed to be looking at the most responsible perpetrators of the worst mass atrocities, and they have to rise to a level in terms of the nature of the crimes, but also the number of the crimes, in order for it to trigger ICC jurisdiction. The fact that U.S. personnel are still being included in this shows clearly that the ICC is not applying its own gravity standard properly, because they would just be going after the Taliban and not including U.S. personnel. And by the way, the ICC could have sidelined U.S. personnel at any point in this process, but they have refused to do so and have persisted in insisting that U.S. personnel can be included in this preliminary investigation.
Ambassador, why do you think they did that? So let me go back, because I was actually president at the creation for the ICC. I was in Rome for the Rome Statute. I was working for the Senate Foreign Relations Committee, and not only did the Senate not ratify, the U.S. not join the treaty and the Senate not ratify it, but the Senate actually passed the American Service Members Protection Act, which is a law that bars all cooperation with the ICC and even authorizes the use of force to protect Americans from coming under its jurisdiction. That passed the Senate 75-19. And we were told all of that was unnecessary because the idea that a rogue prosecutor would one day turn around and come after the United States was ridiculous. That the court was going to focus on grievous human rights abuses by the world's tyrants, and democracies with robust, transparent legal systems had nothing to worry about precisely because of the principle of complementarity. And yet here we are 22 years later, and the ICC is coming after us. Why is it? You mentioned a couple of things where statutes have to be fixed. Is it just the institution is fundamentally flawed, the existence of the institution, the idea that there's a world court, a criminal court, an international criminal court with jurisdiction for a prosecutor that's answerable to no government, no institution, through Proprio Motu action, can just open up a case against the United States or anybody for that matter, Israel has come under its crosshairs as well. I mean, is this court's existence a problem?
So let me be clear that the president and secretary and the Quad cabinet members are determined to do anything necessary to ensure that American personnel are not hauled before the International Criminal Court, and are presenting to the court two options. Number one, change course and amend the Rome Statute so that it will not be possible for American personnel to be hauled before it. Or number two, and the secretary has been clear on this, that the second option would be that the US would seek the dissolution of the court itself. This is very sad because the court is supposed to be pursuing a noble mission of pursuing accountability for mass atrocity crimes, the most serious mass atrocity crimes in the world, of crimes against humanity, war crimes, and genocide. This is a mission that the Office of Global Criminal Justice shares. But this is a misadventure that is actually jeopardizes the sort of intervention that can prevent mass atrocities. And I would also put the US record in regards to seeking to address mass atrocities ahead of certainly the International Criminal Court. And I would put it next to any other record of any other country or entity in the world in terms of all that the US has done along these lines. But the president and the secretary are determined, and the sooner that the ICC realizes this and acts accordingly, the better.
So let's talk a little bit about not just the threat to the US, but to our allies. So Israel's in the court's crosshairs. In 2015, the same prosecutor who's opened this case against the United States opened an investigation of Israel for its actions defending itself against Palestinian terrorists in the West Bank and Gaza, despite the fact that the court has no jurisdiction because Israel's not a party to the treaty, and the Palestinian territories aren't a state party because they're not a state. And yet they're pursuing Israel. Tell us a little bit about that case and what we're doing to protect Israel from the court's jurisdiction.
You're exactly right, Marc. You know, a couple of my predecessors in this office, Ambassador Buchwald and Ambassador Rapp, they put together a brief in which they were making the point that there is no Palestinian state. And so that is the basic basis upon which, in that brief, they are arguing that the ICC cannot assert jurisdiction in that case. And you're exactly right as well, that Israel has not ratified the Rome Statute either. And so we are seeing examples of politicized activity by the ICC, and we also have evidence of corruption as well. And these are greatly concerning. And this is
about the corruption.
I'm sorry.
Tell us about the corruption.
I am not at liberty to go into the classified evidence, but it is, the evidence is strong enough for our secretary to stand up and publicly call it out. I have read deeply into that, but I cannot divulge the nature of it at this point. It is my desire, and I've expressed this, for as much of that evidence to become available to allies and potentially even declassified and made publicly available would be my preference, because this could be potentially the greatest corruption scandal since oil for food.
Wow.
And we have evidence along these lines that's the case. On top of that, the judges of the International Criminal Court are suing the court itself for higher salaries, notwithstanding the fact that they are already paid more than the vast majority of people who work for the American government, for example, and yet they're suing the court for more money. This is, and their record, even by staunch supporters of the court, they recognize how inefficient and ineffective it is. We're talking of only 4 convictions on the substantive crimes that they are supposed to address. 2 out of the 4 the U.S. helped on, and one of those 4 is on appeal. And when you're approaching $2 billion worth of investment and close to 2 decades, and you have that sort of record, and then you want to second guess the United States legal system, and where we have tremendous attorneys and fabulous system. It's borders on a ludicrous, frankly.
So I was reading this weekend Ted Cruz's new book called One Vote Away about the cases before the Supreme Court. He has a chapter on sovereignty, and he talks about a meeting he had with Prime Minister Netanyahu, where he had what he thought was the solution to this problem, which was that to have the U.S. pursue a UN Security Council resolution, which would bar the ICC from bringing a case against a non-state party, and that would do two things. One, it would check the ICC through the power of another international organization as opposed to just the US doing it. And two, it would end up giving the United States a veto power over cases going forward, which was the original solution that Senator Helms and the Foreign Relations Committee had, which was there should be a Security Council screen on cases going forward. Is that Prime Minister Netanyahu's idea something that the US is pursuing or considering pursuing?
That is one of the options in terms of how there could be reform brought to the court, where there would have to be either a Security Council referral or approval becoming necessary in order for it to happen. The Rome Statute already has a Security Council referral mechanism built into it, but to add to that, so that there would have to be Security Council approval before a case could be brought, would be a positive step, and this would be one of the ways in which the ICC could possibly reform and move off of this collision course with the United States.
So the U.S. has imposed sanctions on the prosecutor and several ICC officials, which has been very controversial. Tell us a little bit about that decision and what it entails and why the administration made that decision.
Yes, this is not only infringement upon U.S. sovereignty, but this jeopardizes all sorts of ways that the U.S. Can and does help the world in terms of humanitarian interventions, in terms of military interventions, and things along these lines. And so the president and the secretary are very determined to see that not happen. And this is an expression of the level of determination and seriousness with which our president and secretary, as well as the attorney general and CIA director, also our secretary of defense, and our national security advisor, take this very, very seriously. This is not good for the world, and it's not good for the United States, because the US is the greatest force in the world for justice in regards to prevention of mass atrocities as well as addressing them. And so this was deemed necessary in light of, look, the ICC had many opportunities to off-ramp along these lines, and they chose not to do so. And their persistence in not doing so, there were various efforts that were made previous to the rollout of the executive order. And that was rolled out because the prior efforts that were made were not, did not result in the ICC off-ramping as they could have done earlier to that. So this is an expression of the determination of the president and the secretary, especially along these lines.
So Eli Lake had a column which basically cited some of the statistics you said about how ineffective the ICC has been. It's really been a $2 billion waste of time in terms of getting prosecutions and advancing criminal international justice. The specialized tribunals have done a much better job than the ICC has for Yugoslavia and Rwanda. And he says he basically makes the argument the ICC is kind of a joke. Why elevate it? Why give it legitimacy by putting so much focus on it? Let's just ignore it. Why not ignore them?
So I think the secretary has largely tried to ignore the court, in that we did not argue before the pretrial chamber or the appeals chamber, and we have not addressed any requests for evidence from the U.S. You know, the irony here too is that the court itself was relying on public U.S. documents produced by the U.S. government in order to say, oh, you're not doing good enough job. Well, that's not the way complementarity is supposed to work. You know, when you have voluminous evidence of work done by a functioning system like the US does, it doesn't make sense for the court to step in. And you're exactly right that you can point to all sorts of other results of other courts that the US has very much been involved in supporting, whether it's the International Criminal Tribunal for Yugoslavia, for the former Yugoslavia, the International Criminal Tribunal for Rwanda, the Special Court for Lebanon, the Hybrid Tribunal for Sierra Leone, or for the Central African Republic, the IIIM, the IIM, UNITAD, you know, evidence gathering mechanisms. And if you look at the total record, and you can even go back on this 75th year anniversary of Nuremberg, you can go back starting from Nuremberg and the Tokyo trials. You know, Stalin and Churchill wanted to line up the Nazi war criminals against the wall and shoot them. It was the US who said, let's give them a trial. Let's give them the opportunity to defend themselves in open court. And while most of them were ultimately convicted, there were several actually who were acquitted. And it was the US who led that effort, which was historic, starting from Nuremberg and the Tokyo trials. And frankly, in terms of the formation of the Office of Global Criminal Justice, which is the only foreign ministry in the world that has such an office dedicated to addressing mass atrocity crimes. And over the past almost quarter century, that's exactly what the US has been doing in so many different ways. And there's many other instances I could have mentioned, but I just rattle off some of them.
Are you concerned that not only with the idea of a rogue prosecutor, but U.S. adversaries are weaponizing the ICC against the United States? There's been some reports that some of the evidence and quite frankly the effort to investigate the U.S. in Afghanistan is being led covertly by Russia. That Russia has been providing intelligence to the ICC, which it's using as evidence against the United States. I don't know if you're allowed to comment on that or not, but is it a concern that U.S. adversaries may just take this tool and use it as a weapon against the United States to push us back from the world?
Our Attorney General was confident enough in the evidence that we have to make that statement publicly. I am not allowed to divulge you know, classified information, but suffice it to say that our Attorney General, who is a seasoned and amazing top prosecutor and attorney in his own right in all sorts of ways, believe there's enough evidence to be able to make that statement publicly.
Mm-hmm. So, you know, talk a little bit about if the ICC is not the answer for criminal justice around the world, then how is the U.S. going to lead the cause of criminal justice? I mean, you said in your confirmation statement that the cause of international criminal justice is your life's calling. You've started this career because you want to bring accountability for people who face genocide and atrocities and all the rest of it. If the ICC is not the vehicle, what's the way to do it? You have, you know, the Trump administration has made the historic declaration that ISIS was involved in genocide of Yazidis and Christians and Shia Muslims in Iraq. The administration has also declared that ethnic cleansing took place against Rohingya in Myanmar. How do we produce accountability if not through these supranational judicial institutions?
So the Office of Global Criminal Justice uses intelligence tools, diplomatic tools, military when needed, economic, legal. There's all sorts of different tools that the United States has at its disposal that we can and have used in all sorts of different situations all over the world. My office is involved in all sorts of different places and efforts there, whether it's Sudan in their historic transition, but also trying to address the legacy of past atrocities, or South Sudan and trying to support the formation of a hybrid tribunal to address the atrocities that have that have allegedly occurred in South Sudan, or whether it's the Kosovo Specialist Chambers and that is also trying to address residual mass atrocities in the Balkans, or whether it's in Burma, whether it's the atrocity designations that you're referencing, and there have been a series of atrocity designations that have been made over the years in the history of this office, whether it's seeking and supporting greater accountability in the Middle East in places like Iraq and Syria. There is a whole series of places I could go on, whether it's Guatemala, whether it's Burma, whether it's Colombia. There are all sorts of places that we're employing and deploying all sorts of different tools to try to advance the cause of justice and to do so effectively. Our budget is nowhere close to that of the ICC, I can tell you that. But I would have no problem putting our record up as a government. And it's not just the Office of Global Criminal Justice. We invest billions in humanitarian aid, billions in terms of advancing the rule of law and addressing, criminal syndicates. There's so much that we do all around the world along these lines. There is no force in the world that does more than the United States of America does in all these different places in advancing the cause of justice and the rule of law and addressing mass atrocity crimes.
Is the existence of a independent international criminal court with a independent prosecutor that's free to bring up cases, regardless of the desires of sovereign governments, a deterrent to democratic transitions, in the sense that if you look at most successful democratic transitions that have not involved violence or revolution, they've almost always involved some sort of amnesty. You go back to South Africa, you go back to Chile, most of these countries, if you're going to get a dictator to step down and do so peacefully and not hole up in his presidential palace and fight to the death, you have to negotiate. You have to negotiate often some sort of amnesty. Is the existence of a court that can basically overrule those domestic processes and agreements, is that a deterrent to peaceful democratic transition?
Yeah, I hear exactly what you're saying. And I think this is the sort of thing that needs to be analyzed on a case-by-case basis. And that possibility needs to be made available, even if we are generally for justice. With respect to the Emperor Hirohito, that was a well-known example. He was not prosecuted in the Tokyo trials. It was thought that it was important for Hirohito, in essence, to receive an amnesty in order for the process of transforming Japan and also pursuing these other justice matters. It was considered a prudential judgment that that was the best step in that instance. And so my office generally is more keen on justice than amnesty in general, but there can be instances where it could actually be a legitimate prudential judgment to consider how a particular targeted amnesty could actually help the country more over the long run in a given instance.
Let's take a couple of questions from the audience. We're starting to get some in by email and by Twitter. So one of them comes from AI scholar Ivana Stradner, and she asks, if the ICC argues to have jurisdiction to investigate US individuals, and the ICC also has jurisdiction to prosecute Chinese officials for genocide and crimes against humanity, given that these crimes took place in Cambodia and Tajikistan, that are both signatories to the Rome Statute, why is the ICC silent given that a group of Uyghurs in exile has submitted evidence to the ICC?
That's a good question. You'd have to ask them. They are supposed to be dealing with the worst mass atrocity crimes that are going on. Our secretary has not been shy in calling out the mass atrocities that have been taking place in Xinjiang province, for example, by China. And so this is something that is rather curious. If they are indeed supposed to be focusing on those most responsible for the worst mass atrocities, at a minimum, you have a misappropriation and a mistaken focus and prioritization. And this is one of the things that there's a recent report, independent report that came out that was calling for reform of the ICC. This was not put out by the United States government, and yet it is sounding a lot of the same themes of what I've been sharing and what the U.S. government has been sharing in terms of the critiques of the ICC. And these are people like the former judge, Judge Goldstone, right, who has been involved in these sorts of matters. And even by the staunchest advocates of the court, there is a lot of room for improvement, a lot of room for reform, and a great need for that, even according to this independent report that recently came out.
Ivana had a second follow-up question. Last year, the International Criminal Court prosecutor said she would complete the investigation of the Russia-Georgia 2008 war by the end of 2020. The court's been working on this issue since 2015, and Russia has been ignoring the court and remained silent. Why is the ICC not more active on the Russian case? And I would add, is it possible that the court is sort of ignoring Russia because Russia is providing it with evidence against the United States in the Afghanistan case?
That seems to be where the evidence is pointing, that Russia is wanting to have the focus no longer be on the Ukraine and Georgia, but rather for it to be turned on the United States. And so, yeah, they definitely have motivation and a desire to do that. And so our Attorney General is confident enough in the evidence to publicly state this. This is something that is part of the politicization and the corruption that have been alluded to earlier.
We have a question from Anna. I apologize for butchering your name, Odinstova. She had a couple questions, so I'll just take one of them here. How do you respond to the fact that 175 legal scholars, jurists, and lawyers, including the only surviving American prosecutor at Nuremberg, have condemned the sanctions that the U.S. imposed as wrong in principle, contrary to American values, and prejudicial to U.S. national security?
Well, I would point out that this is actually something that it has been approached in a bipartisan way. There was reference made to the overwhelmingly bipartisan passage of the American Servicemen Protection Act. This is not a Democrat issue or a Republican issue. This is an American issue. And this has been true in the letter we got from Congress, signed by over 300 members of Congress. And I think this would be true regardless of which party is controlling the White House. That is a red line for the United States, that our personnel should be dealt with in our system and not by the International Criminal Court. This is something upon which there is broad bipartisan agreement. I worked as a legal academic myself. I'm familiar with views that are being expressed along these lines. I have high regard for Ben Ferencz, the last living Nuremberg prosecutor. I also have due respect for my former colleagues in legal academia as well. But this is a red line that has been crossed and needs to be addressed. And the president and the secretary are very much determined to do so, as are the Quad cabinet members as well.
Talk a little bit about our record of policing ourselves when it comes to war crimes. Because the fact is, in Afghanistan, the U.S. has carried out over 600 criminal investigations of allegations of misconduct, resulting in more than 250 individuals held to account for misconduct in Afghanistan, ranging from court-martials to prison sentences, reprimands, separation from U.S. military services. The whole idea is, the principle behind the court was supposed to be complementarity, that if we have a functioning legal system and we police our own citizens, then the court has really no role. Talk a little bit about how we've done in terms of policing ourselves because obviously misconduct does take place on the battlefield in handling that misconduct.
Yes, there are robust efforts that take place. The ones that you mentioned, there was a particular instance where, very sadly, a hospital was mistakenly hit in an air attack, and I've reviewed that instance, and I was impressed with the thoroughness and the diligence with which our own system dealt with that. It was a terrible tragedy, and our system robustly did so, even to the point where they were, what we did in that instance was making legitimate airstrikes. Before legitimate airstrikes happened, there was even greater caution that was employed because there was that effort not only to address what happened, but all the efforts that were made to try to help prevent that from happening in the future. I mean, look, our system is considered, if not a model, the model to many countries in the world in terms of our system. And to say that we can't handle these things is absurd. And this is not something that the ICC should be sitting there looking over our shoulder, as the Secretary said, and second guessing what we do in our system. When I spoke at the Naval War College, my interlocutor was noting how there are truly excellent government attorneys who handle these sorts of matters, and I would agree with that. I've seen top-notch, top-drawer government attorneys who are handling things along these lines, and so we are quite capable of handling these sorts of things, and the ICC should not be interfering in our affairs along these lines.
So one of the things they're obviously going after is the CIA's enhanced interrogation program, because that's one of the things that they want to raise in Afghanistan, because allegedly some of those interrogations took place on Afghan territory. And again, in terms of complementarity, the Obama administration appointed a prosecutor, John Durham, to investigate whether the United States violated the torture statutes. And the Obama administration's chosen prosecutor found that, in fact, there were no violations of the torture statutes. And it just seems like to the international legal community, that's an unacceptable result. And so therefore it's illegitimate. And so therefore they're going to use the ICC to try and force accountability for what they see as an illegal program. Talk to us a little bit about how the CIA interrogation program factors into this process.
As you were alluding, there was the Durham report, right? And also there were changes made to the Army Field Manual as well to further try to prevent anything like what was alleged. And so there are all these documents that are available publicly that, in fact, the ICC looked at too, and for them to see the processes that we took and the steps that we took to address these things ourselves, and then to still insist that they're going to move forward with this, is doing nothing resembling honoring the principle of complementarity. It is, in fact, ironically, doing the opposite of that. And so there is thick public documents that put forward all these things, the Durham report, as you were alluding to before. And these are things that that people can investigate and look into if they want. And also what was done in the Senate as well. And so I have copies of these thick documents. They exist. If anyone wants to look into them, they can. And notwithstanding those things, for the ICC to move forward really strongly implies how politicized and, frankly, how corrupt it has become.
So we have a question from Kip Hale, who's a member of the Board of Advisors of the American Bar Association's ICC project. He asks, past U.S. administrations from both parties have provided substantial support to cases at the ICC because those administrations believe support further key U.S. interests, such as the ICC casework in Darfur, Sudan, Libya, Central African Republic, Democratic Republic of Congo, Venezuela, Myanmar, Georgia, and elsewhere. How does the Trump administration reconcile that sanctions do not simply undermine the ICC's ability to work in Afghanistan and Palestine, but undermine the ICC organizationally such that it cannot work in countries the US government believes the ICC should be working and have previously supported?
Let me say that the US has played an important role in supporting what the ICC was doing when we understood it to be advancing justice and to also be consonant with our interests as well. At the same time, I think the Secretary has made it very clear that this sort of cooperation and support, as I mentioned before, out of the 4 substantive convictions they received, half of those were supported by the United States. And arguably, the ICC would not have even gotten half of its substantive convictions without the US. I look forward to the day when the ICC is reformed to the satisfaction of the United States, such that we can continue with such cooperation support for legitimate prosecutions, for legitimate actions that are there. But given the detour that they have taken and the misadventure that they've taken, that is not presently the policy of the United States to continue along those lines. Would look forward to when we could continue to do so with a reformed International Criminal Court.
Another question doesn't have a name attached to it. In the past decade, the U.S. has not intervened militarily to prevent or mitigate atrocities in places where the ICC does not have jurisdiction, including Syria, Myanmar, and South Sudan. If the U.S. has failed to intervene to mitigate atrocities where the ICC does not have jurisdiction now, why would the dissolution of the ICC change the U.S. calculus regarding military intervention? I would note that we actually have intervened in Syria because it was the Obama administration that drew the red line on use of chemical weapons against civilians and never enforced it, and President Trump enforced it twice. So we have actually taken decisive action to prevent the use of chemical weapons, which is a war crime against civilians in Syria. But to the rest of the question, what do you say?
No, you're exactly right. And my opening example was talking about how we had intervened in eliminating the ISIS caliphate in Iraq and Syria. And if that's not a humanitarian intervention that I gave an example of right at the beginning of my opening statement, what is? These were not Americans, hostages who were rescued. These were Iraqis, 75 of them, innocent ones who were taken hostage by ISIS, and it was our soldiers who rescued them. And so saying that we have not done so, I disagree with the predicate of the statement. And we've taken other actions too. We've been supporting the IIIM and UNITAD, which are gathering evidence in regards to Syria and Iraq and supporting domestic prosecutions that are going on in places like Germany and Spain and Sweden and the Netherlands. We also support the IIM, which is gathering evidence in regards to alleged atrocities that have taken place in Burma. We have also publicly sanctioned the top 2 commanders of the Tatmadaw, the Burmese military, as well. I mentioned an array of different tools. Military tools are one type, and we have employed those in intervening on behalf of innocent people. What we've done in the past in northeastern Syria, for example, would be yet another example along these lines. And so I fundamentally disagree with the predicate of the question. And we are engaging in interventions militarily and otherwise to prevent mass atrocities and to advance the cause of justice. Is
international criminal justice a deterrent to atrocities and to aggression? In the sense that if you think about this, is the reason China has not invaded Taiwan because they're worried about being prosecuted by the ICC, or because they're worried about the US military? Is the reason that North Korea does not invade South Korea and unify the Korean Peninsula by force because they're afraid of international criminal justice, or because they're afraid of the consequences from the US military? It seems to me that the impact of the ICC, if it goes after the United States, is to prevent and make it harder and more challenging for the US to intervene militarily on behalf of democracies that are under threat. So the court is actually directly undermining the objective, which is to prevent atrocities rather than simply get justice after the fact.
I think it is clear that it is the American military that is the single biggest deterrent in the examples that you've mentioned. I'll give an example of when President Clinton became president, China decided to test him, and they were amassing military assets around Taiwan. Well, President Clinton had a strong military response in sending our military to answer that threat. Had that not happened, who knows what sort of step that China may have taken in that instance. And the same could be said about currently as well in the present administration. And those are excellent examples that you gave.
So let's say the Trump administration gets another 4 years, and I know you're not involved in politics, but you have the opportunity to continue serving in your post next year and beyond. What are your, as closing question for me, what are your main objectives? One, aside from from preventing the ICC from pursuing Americans, what do you want to achieve with your office?
There's so much we're wanting to achieve. I gave examples from all over the world, and one wishes that this whole office wasn't even needed or necessary, that there were no mass atrocities going on in the world would be my preference. If you asked me if I could have a world where none of this was necessary tomorrow and my office would be cut and I would be cut from it, I would gladly accept that, because these are horrific things that one wishes would never occur. With that said, I will maybe continue and give more examples. Our Congress and President passed the Elie Wiesel Act in terms of trying to prevent atrocities. There was also the Global Fragility Act. And both of those together are trying to amplify and strengthen atrocity prevention, because I do believe that generally an ounce of prevention is better than a pound of cure. There is also the residual mechanism for the International Criminal Tribunal for the former Yugoslavia and the International Criminal Tribunal for Rwanda that are taking the remaining cases that are left in regards to those situations. I think it would be tremendous if the US could pass a robust domestic crimes against humanity legislation that would enable the reach of our prosecution, our domestic system, in being able to prosecute some of these mass atrocity crimes that we're currently more limited in prosecuting because we don't have such a statute. I'd love to have our war crimes rewards program expanded. And by the way, it does cover other atrocity crimes as well. I would love to address the justice gap in the Middle East, in places like Syria and Iraq and Yemen. There's so much I would love to do to advance justice all around the world. I'd love to see Nigeria strengthened in terms of the justice needs that are there, in strengthening Nigeria's system, but also seeing what other ways we could best advance justice in that country. I could go on and on all day long talking about that. And we are very busy in trying to advance all these things in the Office of Global Criminal Justice, where I have a fantastic team of people who are really committed to the mission of advancing justice for these mass atrocity crimes. And it is a privilege and an honor to address these things in and through the United States government and the partners that we have in all over the world in pursuing this very noble mission of justice, both in terms of in prevention, mitigation, as well as in accountability. So thank you for that final question.
Well, thank you so much. We're very blessed to have you, someone so dedicated, working on these issues for the United States government. And maybe a year from now, when we can do this in person, you'll come to AI and we can get an update from you live and in person.
Would look forward to that.
All right. Thank you so much. Thanks everybody for joining us.
Thank you very much.
Bye.
Bye.